Is open. The court meets today pursuant to Article 58 of the statute to deliver its judgment in the case concerning the Jadhav case, India. These proceedings were instituted on 8 May 2017 by the filing in the registry of an application by the Republic of India against the Islamic Republic of Pakistan, alleging violations of the Islamic Republic of Pakistan, alleging violations 4 April 1963, to which I will refer as the Vienna Convention. According to the application of India, and I quote, in the matter of the detention and trial of an Indian national, Mr. Kulbhushan Jadhav, end of quote, accused of performing acts of espionage and terrorism on behalf of India and sentenced to death by a military court in Pakistan in April 2017. As is usual, I shall not read the introductory paragraphs of the judgment, which set out the procedural history of the case and reproduce the submissions of the parties. Nor shall I read the paragraphs which describe the factual background to the case. I shall also omit or summarize some paragraphs of the judgment. The full text of the judgment will, of course, be available at the close of the sitting. I shall accordingly begin reading of the judgment at paragraph 33. With regard to jurisdiction, India seeks to found the court's jurisdiction on Article 36, paragraph 1 of the statute and on Article 1 of the optional protocol to the Vienna Convention on consular relations concerning the compulsory settlement of disputes, to which I will refer as the optional protocol. India and Pakistan have been parties to the Vienna Convention since 28 December 1977 and 14 May 1969, respectively. They also were, at the time of the filing of the application, parties to the optional protocol without any reservations or declarations. The court noticed that Pakistan has not contested that the dispute relates to the interpretation and application of the Vienna Convention, and that the present dispute concerns the question of consular assistance with regard to the arrest, detention, trial, and sentencing of Mr. Jadhav. The court also noticed that in its application, written pleadings, and final submissions, India asks the court to declare that Pakistan has violated Mr. Jadhav's, and I quote, elementary human rights, which are also to be given effect as mandated under Article 14 of the 1966 International Covenant on Civil and Political Rights, end of quote. The covenant entered into force for India on 10 July 1979 and for Pakistan on 23 September 2010. In this respect, the court observes that its jurisdiction in the present case arises from Article 1 of the optional protocol and therefore does not extend to the determination of breaches of international law obligations other than those under the Vienna Convention. This conclusion does not preclude the Court from taking into account other obligations under international law insofar as they are relevant to the interpretation of the Vienna Convention. In light of the foregoing, the Court finds that it has jurisdiction under Article 1 of the optional protocol to entertain India's claims based on alleged violations of the Vienna Convention. The Court now turns to the admissibility of the application. Pakistan has raised 3 objections to the admissibility of India's application. These objections are based on India's alleged abuse of process, abuse of rights, and unlawful conduct. The Court addresses each of these objections in turn. In its first objection to the admissibility of India's application, Pakistan asks the Court to rule that India has abused the Court's procedures. Pakistan advances 2 main arguments to this end. First, it alleges that when requesting the indication of provisional measures on 8 May 2017, India failed to draw the Court's attention to the existence of a constitutional right to lodge a clemency petition. Secondly, Pakistan submitted that before instituting proceedings on 8 May 2017, India had failed to give consideration to other dispute settlement mechanisms envisaged in Articles 2 and 3 of the optional protocol. The Court observes, in relation to Pakistan's first argument, that in its order indicating provisional measures, it took into account the possible consequences for Mr. Jadhavi's situation of the availability under Pakistani law of any appeal or petition procedure, including the clemency petition to which Pakistan refers in support of its claim. In this regard, the Court concluded inter alia, and I quote, that there was considerable uncertainty as to when a decision on any appeal or petition could be rendered, and if the sentence is maintained, as to when Mr. Jadhav could be executed, end of quote. Therefore, there is no basis to conclude that India abused its procedural rights when requesting the Court to indicate provisional measures in this case. In relation to the second argument, the Court notes that none of the provisions of the optional protocol relied on by Pakistan contain preconditions to the Court's exercise of its jurisdiction. The Court interpreted these provisions in the case concerning United States diplomatic and consular staff in Tehran, where it ruled that Articles 2 and 3 of the optional protocol to the Vienna Convention on diplomatic relations and to the Vienna Convention on consular relations do not lay down, and I quote, a precondition of the applicability of the precise and categorical provision contained in Article 1, establishing the compulsory jurisdiction of the Court in respect of disputes arising out of the interpretation or application of the Vienna Convention in question. Articles 2 and 3 provide only that as a substitute for recourse to the Court, the parties may agree upon resort either to arbitration or to conciliation, end of quote. It follows that India was under no obligation in the present case to consider other dispute settlement mechanisms prior to instituting proceedings before the court on 8 May 2017. Thus, Pakistan's objection based on the alleged non-compliance by India with Articles 2 and 3 of the optional protocol cannot be upheld. The court recalls that only in exceptional circumstances should it reject a claim based on a valid title of jurisdiction on the ground of abuse of process. In this regard, there has to be clear evidence that the applicant's conduct amounts to an abuse of process. The court does not consider that in the present case there are such exceptional circumstances that would warrant rejecting India's claims on the ground of abuse of process. Accordingly, the court finds that Pakistan's first objection to the admissibility of India's application must be rejected. With regard to the second objection to the admissibility of India's application, Pakistan requests the court to rule that India has abused various rights it has under international law. In its pleadings, Pakistan has based this objection on three main arguments. First, it refers to India's refusal to provide evidence of Mr. Jadhav's Indian nationality by means of his actual passport in his real name, even though it has a duty to do so. Secondly, Pakistan mentions India's failure to engage with its request for assistance in relation to the criminal investigations into Mr. Jadhav's activities. Thirdly, Pakistan alleges that India authorized Mr. Jadhav to cross the Indian border with, I quote, a false cover name, authentic passport, end of quote, in order to conduct espionage and terrorist activities. In relation to these arguments, Pakistan invokes various counter-terrorism obligations set out in Security Council Resolution 1373 of 2001. In its judgment on the preliminary objections in the case concerning immunities and criminal proceedings, the court ruled that abuse of rights cannot be invoked as a ground of inadmissibility when the establishment of the right in question is properly a matter for the merits. The court notes, however, that by raising the argument that India has not provided the court with the actual passport in Mr. Jadhav's real name, Pakistan appears to suggest that India has failed to prove Mr. Jadhav's nationality. This argument is relevant to the claims based on Article 36 of the Vienna Convention in relation to Mr. Jadhav, and therefore must be addressed at this stage. In this respect, the court observes that the evidence before it shows that both parties have considered Mr. Jadhav to be an Indian national. Indeed, Pakistan has so described Mr. Jadhav on various occasions, including in its letter of assistance for criminal investigation against the Indian national Kulbhushan Jadhav, addressed by the Ministry of Foreign Affairs of Pakistan on 23 January 2017 to the High Commission of India in Islamabad. Consequently, The court is satisfied that the evidence before it leaves no room for doubt that Mr. Jadhav is of Indian nationality. As already indicated, the second and third arguments advanced by Pakistan in support of its second objection to the admissibility of the application are based on various alleged breaches of India's obligations under Security Council Resolution 1373 of 2001. In particular, Pakistan refers to India's failure to respond to Pakistan's request for mutual legal assistance with its criminal investigations into Mr. Jadhav's espionage and terrorism activities, as well as the issuance of what Pakistan describes as, and I quote, a false cover name, authentic passport, end of quote. The court observes that, in essence, Pakistan seems to argue that India cannot request consular assistance with respect to Mr. Jadhav, while at the same time it has violated other obligations under international law as a result of the aforementioned acts. While Pakistan has not clearly explained the link between these allegations and the rights invoked by India on the merits, it is the court's view that such allegations are properly a matter for the merits and therefore cannot be invoked as a ground of inadmissibility. For these reasons, the court finds that Pakistan's second objection to the admissibility of India's application must be rejected. The second and third arguments advanced by Pakistan will be addressed later when dealing with the merits. The court now turns to the third objection to the admissibility of India's application, whereby Pakistan asks the court to dismiss the application on the basis of India's alleged unlawful conduct. Relying on the doctrine of clean hands and the principles of ex turbi causa non oritur actio and ex injuria jus non oritur, Pakistan contends that India has failed to respond to its request for assistance with the investigation into Mr. Jadhav's activities, that it has provided him with, I quote, a false cover name, authentic passport, end of quote, and more generally, that it is responsible for Mr. Jadhav's espionage and terrorism activities in Pakistan. The court does not consider that an objection based on the clean hands doctrine may by itself render an application based on a valid title of jurisdiction inadmissible. It recalls that in the case concerning certain Iranian assets, Islamic Republic of Iran versus United States of America, the court ruled that even if it were shown that the applicant's conduct was not beyond reproach, this would not be sufficient per se to uphold the objection to admissibility raised by the respondent on the basis of the clean hands doctrine. The court therefore concludes that Pakistan's objection based on the said doctrine must be rejected. The court further notes that Pakistan has relied on the judgment of the Permanent Court of International Justice in the Factory at Chorso case in order to advance an argument based on a principle to which it refers as ex turbi causa non oritur actio. However, in that case, the Permanent Court referred to a principle, and I quote, generally accepted in the jurisprudence of international arbitration, as well as by municipal courts, that one party cannot avail himself of the fact that the other has not fulfilled some obligation if the former party has, by some illegal act, prevented the latter from fulfilling the obligation in question, end of quote. With regard to this principle, the court is of the view that Pakistan has not explained how any of the wrongful acts allegedly committed by India may have prevented Pakistan from fully fulfilling its obligation in respect of the provision of consular assistance to Mr. Jadhav. The court therefore finds that Pakistan's objection, based on the principle of ex turbi causa non oritur actio, cannot be upheld. This finding leads the court to a similar conclusion with regard to the principle of ex injuria jus non oritur, which stands for the proposition that unlawful conduct cannot modify the law applicable in the relations between the parties. In the view of the court, this principle is inapposite to the circumstances of the present case. Accordingly, the court finds that Pakistan's third objection to the admissibility of India's application must be rejected. In light of the foregoing, the court concludes that the three objections to the admissibility of the application raised by Pakistan must be rejected and that India's application is admissible. The court now turns to the merits of India's application. In this regard, the court recalls that Pakistan does not expressly raise any objection to the jurisdiction of the court. It notes, however, that Pakistan does advance several contentions concerning the applicability of certain provisions of the Vienna Convention to the case of Mr. Jadhav. The court considers it appropriate to address these arguments first before turning to the alleged violations by Pakistan of its obligations under Article 36 of the Vienna Convention. The court notes that Pakistan's contentions regarding the applicability of the Vienna Convention are threefold. First, Pakistan argues that Article 36 of the Vienna Convention does not apply in prima facie cases of espionage. Secondly, Pakistan contends that customary international law governs cases of espionage in consular relations and allows states to make exceptions to the provisions on consular access contained in Article 36 of the Vienna Convention. Thirdly, Pakistan maintains that it is the 2008 agreement on consular access between India and Pakistan, rather than Article 36 of the Vienna Convention, which regulates consular access in the present case. The court will address each of these arguments in turn. With regard to Pakistan's first contention, the court begins by noting that India is not a party to the 1969 Vienna Convention on the Law of Treaties, whereas Pakistan signed that convention on 29 April 1970, but has not ratified it. Accordingly, the court will interpret the Vienna Convention on Consular Relations according to the customary rules of treaty interpretation, which, as it has stated on many occasions, are reflected in Articles 31 and 32 of the Vienna Convention on the Law of Treaties. The Court observes that neither Article 36 nor any other provision of the Vienna Convention contains a reference to cases of espionage, nor does Article 36 exclude from its scope, when read in its context and in light of the object and purpose of the Convention, certain categories of persons, such as those suspected of espionage. The object and purpose of the Vienna Convention, as stated in its preamble, is to, I quote, contribute to the development of friendly relations among nations, end of quote. The purpose of Article 36, paragraph 1 of the Convention, as indicated in its introductory sentence, is to, I quote, facilitate the exercise of consular functions relating to nationals of the sending state, end of quote. Consequently, consular officers may, in all cases, exercise the rights relating to consular access set out in that provision for the nationals of the sending state. It would run counter to the purpose of that provision if the rights it provides could be disregarded when the receiving state alleges that a foreign national in its custody was involved in acts of espionage. The Court thus concludes that when interpreted in accordance with the ordinary meaning to be given to the terms of the Vienna Convention, in their context and in light of its object and purpose, Article 36 of the Convention does not exclude from its scope certain categories of persons, such as those suspected of espionage. In view of this conclusion, the Court need not, in principle, resort to supplementary means of interpretation, such as the travaux préparatoires of the Vienna Convention and the circumstances of its conclusion, to determine the meaning of Article 36 of the Convention. However, as in other cases, the Court may have recourse to the travaux préparatoires in order to confirm its interpretation of Article 36 of the Vienna Convention. During the discussions of the International Law Commission on the topic of consular intercourse and immunities, there was no suggestion that Article 36 would not apply to certain categories of persons, such as those suspected of espionage. Draft Article 30A, which served as a basis for Article 36 of the Convention, was discussed by the Commission in 1960. It provided in the relevant part, and I quote, that the local authorities shall inform the consul of the sending state without delay when any national of that state is detained in custody within his district. Among the issues discussed in relation to this provision was the question whether and to what extent it was conceivable for consular notification to be made without delay in countries which had a system of detention incommunicado, whereby the person might be held isolated from the outside world for a certain period at the beginning of a criminal investigation. With regard to cases of espionage, the chairman of the Commission remarked that, and I quote, a statement of a general principle of law could not possibly cover all conceivable cases. If the Commission went into the question of whether cases of espionage should be made an exception, the whole principle of consular protection and communication with nationalists would have to be reopened. End of quote. And communication with nationalists was not reopened. The court further noticed that cases of espionage were also mentioned in the context of the Commission's discussions on the possible inclusion of a reference to security zones in the proposed provision. However, there was no suggestion of consular access not being granted in cases of espionage because of national security concerns. During its 1961 session, the Commission decided to change the words "without delay" to "without undue delay." The Court observes that this decision had no implication for the scope of draft Article 36. The Commission's commentary to draft Article 36, paragraph 1b, merely states that, and I quote, "the expression without undue delay used in paragraph 1b allows for cases where it is necessary to hold a person incommunicado for a certain period for the purposes of the criminal investigation." End of quote. During the United Nations Conference on Consular Relations held in Vienna from 4 March to 22 April 1963, the question of espionage was raised in relation to the words "without undue delay" in draft Article 36. The chairman invited Mr. Zurek, the former special rapporteur of the International Law Commission on this topic, to explain why the International Law Commission had included the words "without undue delay" in its draft. The explanation given by Mr. Zurek suggests that while the charge of espionage was thought to be relevant in determining the appropriate period of time within which notification to the sending state should be made by the receiving state, cases of espionage were not excluded from the scope of the Vienna Convention. The Court further noticed that in the course of the discussion on proposed amendments to draft Article 36, including a proposal by the United Kingdom to delete the word "undue" from the phrase "without undue delay," which was eventually adopted, it was not suggested that certain categories of persons, such as those suspected of espionage, were to be excluded from the protection of the Convention. The travaux préparatoires thus confirm the interpretation that Article 36 does not exclude from its scope certain categories of persons, such as those suspected of espionage. Turning now to Pakistan's second argument regarding the existence of an alleged espionage exception under customary international law, the Court noticed that the preamble of the Vienna Convention states that the rules of customary international law continue to govern matters not expressly regulated by the provisions of the present Convention. Article 36 of the Convention expressly regulates the question of consular access to and communication with nationals of the sending state and makes no exception with regard to cases of espionage. the court recalls that India and Pakistan have been parties to the Vienna Convention since 1977 and 1969, respectively, and that neither party attached any reservation or declaration to the provisions of the Convention. The Court therefore considers that Article 36 of the Convention, and not customary international law, governs the matter at hand in the relations between the parties. Having reached this conclusion, the Court does not find it necessary to determine whether, when the Vienna Convention was adopted in 1963, there existed the rule of customary international law that Pakistan advances. The Court will now turn to Pakistan's third contention that the 2008 agreement on consular access between India and Pakistan governs consular access in the present case. The Court recalls that point 6 of the 2000 agreement provides that, and I quote, "In case of arrest, detention, or sentence made on political or security grounds, each side may examine the case on its merits," end of quote. It also recalls that in the preamble of the agreement, the parties declared that they were, and I quote, "desirous of furthering the objective of humane treatment of nationals of either country arrested, detained, or imprisoned in the other country," end of quote. The Court is of the view that point 6 of the agreement cannot be read as denying consular access in the case of an arrest, detention, or sentence made on political or security grounds. Given the importance of the rights concerned in guaranteeing the humane treatment of nationals of either country, arrested, detained, or imprisoned in the other country, if the parties had intended to restrict in some way the rights guaranteed by Article 36, one would expect such an intention to be unequivocally reflected in the provisions of the agreement. That's not the case here. Moreover, as already noted, with reference to the alleged exception of espionage in the Vienna Convention, any derogation from Article 36 of the Vienna Convention for political or security grounds may render the right related to consular access meaningless, as it would give the receiving state the possibility of denying such access. Account should also be taken of Article 73, paragraph 2 of the Vienna Convention for the purpose of interpreting the 2008 agreement. This paragraph provides, and I quote, "that nothing in the present convention shall preclude states from concluding international agreements, confirming or supplementing or extending or amplifying the provisions thereof," end of quote. The language of this paragraph indicates that it refers to subsequent agreements to be concluded by parties to the Vienna Convention. The Court notes that the Vienna Convention was drafted with a view to establishing, to the extent possible, uniform standards for consular relations. The ordinary meaning of Article 73, paragraph 2, suggests that it is consistent with the Vienna Convention to conclude only nationals not covered by the Convention. The parties have negotiated the 2008 agreement in full awareness of Article 73, paragraph 2 of the Vienna Convention. Having examined that agreement, and in light of the conditions set out in Article 73, paragraph 2, the Court is of the view that the 2008 agreement is a subsequent agreement intended to confirm, supplement, extend, or amplify the Vienna Convention. Consequently, the Court considers that point 6 of that agreement does not, as Pakistan contends, displace the obligations under Article 36 of the Vienna Convention. For these reasons, the Court finds that none of the arguments raised by Pakistan concerning the applicability of Article 36 of the Vienna Convention to the case of Mr. Jadhav can be upheld. The Court thus concludes that the Vienna Convention is applicable in the present case, regardless of the allegations that Mr. Jadhav was engaged in espionage activities. Having concluded that the Vienna Convention is applicable in the present case, the Court proceeds to examine the alleged violations by Pakistan of its obligations under Article 36 thereof. India contends in its final submissions that Pakistan acted in breach of its obligations under Article 36 of the Vienna Convention, first, by not informing India without delay of the detention of Mr. Jadhav. Second, by not informing Mr. Jadhav of his rights under Article 36. And third, by denying consular officers of India access to Mr. Jadhav, contrary to their right to visit him, to converse and correspond with him, and to arrange for his legal representation. The Court will consider the alleged violations in chronological order. Turning now to India's submission regarding the alleged failure of Pakistan to inform Mr. Jadhav of his rights under Article 36, paragraph 1b of the Vienna Convention, the Court recalls that under this provision, the competent authorities of the receiving state must inform a foreign national in detention of his rights in accordance with it. The Court therefore needs to determine whether the competent Pakistani authorities informed Mr. Jadhav of his rights in accordance with this provision. In this respect, the Court observes that Pakistan has not contested India's contention that Mr. Jadhav was not informed of his rights under Article 36, paragraph 1b of the Convention. To the contrary, in the written and oral proceedings, Pakistan consistently maintained that the Convention does not apply to an individual suspected of espionage. The Court infers from this position of Pakistan that it did not inform Mr. Jadhav of his rights under Article 36, paragraph 1b of the Vienna Convention, and thus concludes that Pakistan breached its obligation to inform Mr. Jadhav of his rights under that provision. With regard to India's submission regarding the alleged failure of Pakistan to inform India without delay of the arrest and detention of Mr. Jadhav, the Court recalls that Article 36, paragraph 1b of the Vienna Convention provides that if a national of the sending state is arrested or detained, and if he so requests, the competent authorities of the receiving state must, without delay, inform the consular post of the sending state. To examine India's claim that Pakistan breached its obligation under this provision, the court will consider first whether Mr. Jadhav made such a request, and second, whether Pakistan informed India's consular post of the arrest and detention of Mr. Jadhav. Finally, if the court finds that notification was provided by Pakistan, it will examine whether it was made without delay. Interpreting Article 36, paragraph 1b, in accordance with the ordinary meaning of the terms used, the court notes that there is an inherent connection between the obligation of the receiving state to inform a detained person of his rights under Article 36, paragraph 1b, and his ability to request that the consular post of the sending state be informed of his detention. Unless the receiving state has fulfilled its obligation to inform a detained person of his rights under Article 36, paragraph 1b, he may not be aware of such rights and consequently may not be in a position to make a request that the competent authorities of the receiving state inform the sending state's consular post of his arrest. The travaux préparatoires confirm the connection between the obligation of the receiving state to inform a detained person of his rights and his ability to request that the consular post of the sending state be informed of his detention. In light of the foregoing, the phrase, "if he so requests," must be read in conjunction with the obligation of the receiving state to inform the detained person of his rights under Article 36, paragraph 1b. The court has already found that Pakistan failed to inform Mr. Jadhav of his rights. Consequently, the court is of the view that Pakistan was under an obligation to inform India's consular post of the arrest and detention of Mr. Jadhav in accordance with Article 36, paragraph 1b of the Convention. Moreover, the court observes that when a national of the sending state is in prison, custody, or detention, an obligation of the authorities of the receiving state to inform the consular post of the sending state is implied by the rights of the consular officers under Article 36, paragraph 1c, to visit the national, to converse and correspond with him, and to arrange for his legal representation. The court now proceeds to the second question, that of whether Pakistan informed India of the arrest and detention of Mr. Jadhav. On 25 March 2016, the Foreign Secretary of Pakistan summoned the Indian High Commissioner in Islamabad to raise the matter of the arrest and issued a démarche protesting the illegal entry into Pakistan of an officer from India's foreign intelligence agency known as Research and Analysis Wing. The court observes that Article 36, paragraph 1b does not specify the manner in which the receiving state should inform the consular post of the sending state of the detention of one of its nationals. What's important is that the information contained in the notification is sufficient to facilitate the exercise by the sending state of the consular rights envisaged by Article 36, paragraph 1 of the Vienna Convention. Pakistan's action on 25 March 2016 enabled India to make a request for consular access on the same day. Under the circumstances, the court considers that Pakistan notified India on 25 March 2016 of the arrest and detention of Mr. Jadhav as required by Article 36, paragraph 1b of the Vienna Convention. The court now turns to the final question, that of whether the notification was given without delay. Pakistan claims that at the time of his arrest on 3 March 2016, Mr. Jadhav was in possession of an Indian passport bearing the name Hussein Mubarak Patel. In the circumstances of the present case, the court considers that there were sufficient grounds at the time of the arrest on 3 March 2016 or shortly thereafter for Pakistan to conclude that the person was or was likely to be an Indian national, thus triggering its obligation to inform India of his arrest in accordance with Article 36, paragraph 1b of the Vienna Convention. There was a delay of some 3 weeks between Mr. Jadhav's arrest on 3 March 2016 and the notification made to India on 25 March 2016. The court recalls that neither the terms of the Vienna Convention as normally understood, nor its object and purpose, suggested that without delay is to be understood as immediately upon arrest and before interrogation. The court also recalls that there is no suggestion in the travaux préparatoires that the phrase without delay might have different meanings in each of the 3 sets of circumstances in which it is used in Article 36, paragraph 1b. In the Avena case, the court's determination whether notification had been given without delay was made on the basis of each individual's circumstances. The court found that there had been a violation of the obligation to inform under Article 36, paragraph 1b with regard to a delay of just 40 hours when the foreign nationality of the detained person was apparent from the outset of his detention. However, the court found no violation in respect of a delay of 5 days when the foreign nationality was less obvious at the time of the arrest. Taking account of the particular circumstances of the present case, the court considers that the fact that the notification was made some 3 weeks after the arrest in this case constitutes a breach of the obligation to inform without delay as required by Article 36, paragraph 1b of the Vienna Convention. The court will now address India's third submission concerning the alleged failure of Pakistan to provide consular access to Mr. Jadhav. The court notes that Article 36, paragraph 1a of the Vienna Convention provides that, and I quote, consular officers shall be free to communicate with nationals of the sending state and to have access to them. Nationals of the sending state shall have the same freedom with respect to communication with and access to consular officers of the sending state. End of quote. Paragraph 1c provides inter alia, and I quote, that consular officers shall have the right to visit a national of the sending state who is in prison, custody, or detention to converse and correspond with him, end of quote. The court recalls that Article 36, paragraph 1 creates individual rights which by virtue of Article 1 of the optional protocol may be invoked in this court by the national state of the detained person. In the present case, it is undisputed that Pakistan has not granted any Indian consular officer access to Mr. Jadhav. India has made a number of requests for consular access since 25 March 2016. Pakistan responded to India's request for consular access for the first time in its note verbal dated 21 March 2017, in which it stated that, and I quote, "The case for the consular access to the Indian national, Kulbhushan Jadhav, shall be considered in the light of Indian side's response to Pakistan's request for assistance in the investigation process and early dispensation of justice," end of quote. The court is of the view that the alleged failure by India to cooperate in the investigation process in Pakistan does not relieve Pakistan of its obligation to grant consular access under Article 36, paragraph 1 of the Convention, and does not justify Pakistan's denial of access to Mr. Jadhav by consular officers of India. The court further notes that Article 36, paragraph 1c provides that consular officers have the right to arrange legal representation for a detained national of the sending state. This provision presupposes that consular officers can arrange legal representation based on conversation and correspondence with the detained person. In the view of the court, Pakistan's contention that Mr. Jadhav was allowed to choose a lawyer for himself, but that he opted to be represented by a defending officer qualified for legal representation, even if it is established, does not dispense with the consular officer's right to arrange for his legal representation. The court therefore concludes that Pakistan has breached the obligations incumbent on it under Article 36, paragraph 1a and c of the Vienna Convention by denying consular officers of India access to Mr. Jadhav, contrary to their right to visit him, to converse and correspond with him, and to arrange for his legal representation. Having concluded that Pakistan acted in breach of its obligations under Article 36, paragraphs 1a, b, and c of the Vienna Convention, the court now proceeds to examine Pakistan's contentions based on abuse of rights. In this context, the court will determine whether India's alleged violations of international law invoked by Pakistan in support of its contentions based on abuse of rights may constitute a defense on the merits. In essence, Pakistan argues that India cannot request consular assistance with respect to Mr. Jadhav, while at the same time it has failed to comply with other obligations under international law. The court recalls in this respect that the Vienna Convention, and I quote, lays down certain standards to be observed by all state parties with a view to the unimpeded conduct of consular relations, end of quote. And that Article 36 on consular assistance to and communication with nationals undergoing criminal proceedings sets forth rights both for the state and the individual, which are interdependent. In the court's view, there is no basis under the Vienna Convention for a state to condition the fulfillment of its obligations under Article 36 on the other state's compliance with other international law obligations. Otherwise, the whole system of consular assistance would be severely undermined. For these reasons, the court concludes that none of Pakistan's allegations relating to abuse of rights by India justifies breaches by Pakistan of its obligations under Article 36 of the Vienna Convention. Pakistan's argument in this respect cannot therefore be upheld. The court now turns to the question of the remedies sought by India in its final submissions. In summary, India requests the court to adjudge and declare that Pakistan acted in breach of Article 36 of the Vienna Convention on consular relations. Pursuant to the foregoing, India asks the court to declare that the sentence of Pakistan's military court imposed on Mr. Jadhav is violative of international law and the provisions of the Vienna Convention, and that India is entitled to restitutio in integrum. It also requests the court to annul the decision of the military court and restrain Pakistan from giving effect to the sentence or conviction, and to direct Pakistan to release Mr. Jadhav and to facilitate his safe passage to India. In the alternative, and if the court were to find that Mr. Jadhav is not to be released, India requests the court to annul the decision of the military court and restrain Pakistan from giving effect to the sentence awarded by the military court in Pakistan. In the further alternative, India asks the court to direct Pakistan to take steps to annul the decision of the military court. In either event, it requests the court to direct a trial under ordinary law before civilian courts after excluding Mr. Jadhav's confession and is in strict conformity with the provisions of the International Covenant on Civil and Political Rights, with full consular access and with a right for India to arrange for Mr. Jadhav's legal representation. The court has already found that Pakistan acted in breach of its obligations under Article 36 of the Vienna Convention, first by not informing Mr. Jadhav of his rights under Article 36, paragraph 1b, secondly, by not informing India without delay of the arrest and detention of Mr. Jadhav, and thirdly, by denying access to Mr. Jadhav by consular officers of India, contrary to their right inter alia to arrange for his legal representation. The court considers that the first and third breaches by Pakistan, as set out above, constitute internationally wrongful acts of a continuing character. Accordingly, the court is of the view that Pakistan is under an obligation to cease those acts and to comply fully with its obligations under Article 36 of the Vienna Convention. Consequently, Pakistan must inform Mr. Jadhav without further delay of his rights under Article 36, paragraph 1b, and allow Indian consular officers to have access to him and to arrange for his legal representation as provided by Article 36, paragraph 1a and c. With regard to India's submission that the court declared that the sentence handed down by Pakistan's military court is violative of international law and the provisions of the Vienna Convention, the court recalls that its jurisdiction has its basis in Article 1 of the optional protocol. This jurisdiction is limited to the interpretation or application of the Vienna Convention and does not extend to India's claims based on any other rules of international law. India refers to Article 14 of the International Covenant on Civil and Political Rights to support its requests for remedies. In accordance with the rule reflected in Article 31, paragraph 3c of the Vienna Convention on the Law of Treaties, the covenant may be taken into account together with the context for the interpretation of the Vienna Convention on Consular Relations. The court notes, however, that the remedy to be ordered in this case has the purpose of providing reparation only for the injury caused by the internationally wrongful act of Pakistan that falls within the court's jurisdiction, namely its breach of obligations under Article 36 of the Vienna Convention on Consular Relations and not of the Covenant. As regards India's claim based on the Vienna Convention, the court considers that it's not the conviction and sentence of Mr. Jadhav which are to be regarded as a violation of the provisions of the Vienna Convention. In the Avena case, the court confirmed that, and I quote, the case before it concerns Article 36 of the Vienna Convention and not the correctness as such of any conviction or sentencing, and that it is not the convictions and sentences of the Mexican nationals which are to be regarded as a violation of international law, but solely certain breaches of treaty obligations on consular access which preceded them, end of quote. With regard to India's contention that it is entitled to restitutio in integrum and its request to annul the decision of the military court and to restrain Pakistan from giving effect to the sentence or conviction, and it is further request to direct Pakistan to take steps to annul the decision of the military court, to release Mr. Jadhav and to facilitate his safe passage to India, the court reiterates that it's not the conviction and sentence of Mr. Jadhav which are to be regarded as a violation of Article 36 of the Vienna Convention. The court also recalls that it is not to be presumed that partial or total annulment of conviction or sentence provides the sole and necessary remedy in cases of violations of Article 36 of the Vienna Convention. Thus, the court finds that these submissions made by India cannot be upheld. The court reaffirms that it's a principle of international law that any breach of an engagement involves an obligation to make reparation, and that reparation must, as far as possible, wipe out all the consequences of the illegal act. The court considers the appropriate remedy in this case to be effective review and reconsideration of the conviction and sentence of Mr. Jadhav. This is consistent with the approach that the court has taken in cases of violations of Article 36 of the Convention. It's also in line with what the applicant asks the court to adjudge and declare in the present case. In the court's view, India ultimately requests effective remedies for the breaches of the Convention by Pakistan. The court notes that Pakistan acknowledges that the appropriate remedy in the present case would be effective review and reconsideration of the conviction and sentence. The court considers that a special emphasis must be placed on the need for the review and reconsideration to be effective. The review and reconsideration of the conviction and sentence of Mr. Jadhav, in order to be effective, must ensure that full weight is given to the effect of the violation of the rights set forth in Article 36, paragraph 1 of the Convention, and guarantee that the violation and the possible prejudice caused by the violation are fully examined. It presupposes the existence of a procedure which is suitable for this purpose. The court observes that it is normally the judicial process which is suited to the task of review and reconsideration. In the present case, the death sentence imposed on Mr. Jadhav by the Field General Court Martial of Pakistan was confirmed by the Chief of Army Staff on 10 April 2017. The evidence suggests that Mr. Jadhav appealed to the Military Appellate Court under Section 133B of the Pakistan Army Act of 1952, but that the appeal was rejected. With regard to the petition procedure, the evidence suggests that Mr. Jadhav has made a mercy petition to the Chief of Army Staff and that the mother of Mr. Jadhav has sought to file a petition with the federal government of Pakistan under Section 131 and an appeal under Section 133B of the Act. There is no evidence before the court to indicate the outcome of these petitions or that appeal. The court noticed that according to Pakistan, the high courts of Pakistan can exercise review jurisdiction. The court observes, however, that Article 199, paragraph 3 of the Constitution of Pakistan has been interpreted by the Supreme Court of Pakistan as limiting the availability of such review for a person who is subject to any law relating to the armed forces of Pakistan, including the Pakistan Army Act of 1952. The Supreme Court has stated that the High Courts and Supreme Court may exercise judicial review over a decision of the Field General Court Martial on, and I quote, the grounds of coram non judice, without jurisdiction or suffering from mala fides, including malice in law only, end of quote. Article 8, paragraph 1 of the Constitution provides that any law which is inconsistent with fundamental rights guaranteed under the Constitution is void. But this provision does not apply to the Pakistan Army Act of 1952 by virtue of a constitutional amendment. that it's not clear whether judicial review of a decision of a military court is available on the ground that there has been a violation of the rights set forth in Article 36, paragraph 1 of the Vienna Convention. The court takes, however, note of the decision of the Peshawar High Court in 2018. The High Court held that it had the legal mandate positively to interfere with decisions of military courts, and I quote, if the case of the prosecution was based firstly on no evidence, secondly, insufficient evidence, and thirdly, absence of jurisdiction, finally, malice of facts and law. The government of Pakistan has appealed the decision, and the case was still pending at the close of the oral proceedings in the present case. The court confirms that the clemency process is not sufficient in itself to serve as an appropriate means of review and reconsideration, but that appropriate clemency procedures can supplement judicial review and reconsideration, in particular where the judicial system has failed to take due account of the violation of the rights set forth in the Vienna Convention. The evidence before the court suggests that two clemency procedures are available to Mr. Jadhav: a mercy petition to the Chief of Army Staff within 60 days of the decision by the appellate court, and a mercy petition to the President of Pakistan within 90 days of the decision of the Chief of Army Staff on the mercy petition. The outcome of the petition submitted by Mr. Jadhav to the Chief of Army Staff has not, however, been made known to the court. No evidence has been submitted to the court regarding the presidential clemency procedure. In light of these circumstances, the court considers it imperative to re-emphasize that the review and reconsideration of the conviction and sentence of Mr. Jadhav must be effective. In this regard, the court takes full cognizance of the representations made by Pakistan. During the oral proceedings, the agent of Pakistan declared that the Constitution of Pakistan guarantees as a fundamental right the right to a fair trial, that the right to a fair trial is, I quote, absolute and cannot be taken away, end of quote, and that all trials are conducted accordingly, and if not, and I quote, the process of judicial review is always available, end of quote. Counsel for Pakistan also assured the court that the high courts of Pakistan exercise, and I quote, effective review jurisdiction, end of quote, giving as an example the decision of the Peshawar High Court in 2018. The court points out that respect for the principles of a fair trial is of cardinal importance in any review and reconsideration, and that in the circumstances of the present case, it is essential for the review and reconsideration of the conviction and sentence of Mr. Jadhav to be effective. The court considers that the violation of the rights set forth in Article 36, paragraph 1 of the Vienna Convention and its implications for the principles of a fair trial should be fully examined and properly addressed during the review and reconsideration process. In particular, any potential prejudice and the implications for the evidence and the right of defense of the accused should receive close scrutiny during the review and reconsideration. The Court notes that the obligation to provide effective review and reconsideration can be carried out in various ways. The choice of means is left to Pakistan. Nevertheless, freedom in the choice of means is not without qualification. The obligation to provide effective review and reconsideration is an obligation of result which must be performed unconditionally. Consequently, Pakistan shall take all measures to provide for effective review and reconsideration, including, if necessary, by enacting appropriate legislation. To conclude, the Court finds that Pakistan is under an obligation to provide, by means of its own choosing, effective review and reconsideration of the conviction and sentence of Mr. Jadhav, so as to ensure that full weight is given to the effect of the violation of the rights set forth in Article 36 of the Vienna Convention, taking account of paragraphs 139, 145, and 146 of this judgment. The Court recalled that it issued an order on provisional measures, directing Pakistan to take all measures at its disposal to ensure that Mr. Jadhav is not executed pending the final decision in the present proceedings. The Court considers that a continued stay of execution constitutes an indispensable condition for the effective review and reconsideration of the conviction and sentence of Mr. Jadhav. I shall now read out paragraph 149, the operative part of the judgment. For these reasons, the Court, 1, unanimously finds that it has jurisdiction on the basis of Article 1 of the optional protocol concerning the compulsory settlement of disputes to the Vienna Convention on Consular Relations of 24 April 1963 to entertain the application filed by the Republic of India on 8 May 2017. 2, by 15 votes to 1, rejects the objections by the Islamic Republic of Pakistan to the admissibility of the application of the Republic of India and finds that the application of the Republic of India is admissible. In favor, President Yusuf, Vice President Shue, Judges Tomka Abraham Benuna, Cansado Trinidad Donahue, Gaia Sebutinde Bandari Robinson, Crawford, Gevorgian, Salam, Iwasawa. Against, Judge Ad hoc Gilani. 3, by 15 votes to 1, finds that by not informing Mr. Kulbhushan Jadhav without delay of his rights under Article 36, paragraph 1b of the Vienna Convention on Consular Relations, the Islamic Republic of Pakistan breached the obligations incumbent upon it under that provision. In favor, President Yusuf, Vice President Shue, Judges Tomka Abraham Benuna, Cansado Trinidad Donahue, Gaia Sebutinde Bandari Robinson, Crawford, Gevorgian, Salam, Iwasawa against Judge Ad hoc Gilani. 4. By 15 votes to 1, finds that by not notifying the appropriate consular post of the Republic of India in the Islamic Republic of Pakistan without delay of the detention of Mr. Kulbhushan Jadhav and thereby depriving the Republic of India of the right to render the assistance provided for by the Vienna Convention to the individual concerned, the Islamic Republic of Pakistan breached the obligations incumbent upon it under Article 36, Paragraph 1b of the Vienna Convention on Consular Relations. In favor, President Yusuf, Vice President Shue, Judges Tomka, Abraham, Benuna, Cansado, Trinidade, Donahue, Gaya, Sebutinde, Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, against Judge Ad hoc Gilani. 5. By 15 votes to 1, finds that the Islamic Republic of Pakistan deprived the Republic of India of the right to communicate with and have access to Mr. Kulbhushan Jadhav, to visit him in detention and to arrange for his legal representation, and thereby breached the obligations incumbent upon it under Article 36, Paragraph 1a and c of the Vienna Convention on Consular Relations. In favor, President Yusuf, Vice President Shue, Judges Tomka, Abraham, Benuna, Cansado, Trinidade, Donahue, Gaya, Sebutinde, Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, against Judge Ad hoc Gilani. 6. By 15 votes to 1, finds that the Islamic Republic of Pakistan is under an obligation to inform Mr. Kulbhushan Jadhav without further delay of his rights and to provide Indian consular officers access to him in accordance with Article 36 of the Vienna Convention on Consular Relations. In favor, President Yusuf, Vice President Shue, Judges Tomka, Abraham, Benuna, Cansado, Trinidade, Donahue, Gaya, Sebutinde, Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, against Judge Ad hoc Gilani. 7. By 15 votes to 1, finds that the appropriate reparation in this case consists in the obligation of the Islamic Republic of Pakistan to provide, by means of its own choosing, effective review and reconsideration of the conviction and sentence of Mr. Kulbhushan Jadhav so as to ensure that full weight is given to the effect of the violation of the rights set forth in Article 36 of the Convention, taking account of paragraphs 139, 145, and 146 of this judgment. In favor, President Yusuf, Vice President Shue, Judges Tomka, Abraham, Benuna, Cansado, Trinidade, Donahue, Gaya, Sebutinde, Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, against Judge Ad hoc Gilani. 8. By 15 votes to 1, declares that a continued stay of execution constitutes an indispensable condition for the effective review and reconsideration of the conviction and sentence of Mr. Kulbhushan Jadhav. In favor, President Yusuf, Vice President Shue, Judges Tomka, Abraham, Benuna, Cansado, Trinidade, Donahue, Gaya, Sebutinde, Bandari, Robinson, Crawford, Gevorgian, Salam Iwasawa against Judge ad hoc Gilani. I shall now call upon the Deputy Registrar to read the operative part of the judgment in French. You have the floor.
Par ces motifs, la Cour, 1. À l'unanimité, dit qu'elle a compétence sur le fondement de l'article 1er du protocole de signature facultative à la Convention de Vienne sur les relations consulaires du 27 avril 1963 concernant le règlement obligatoire des différends pour connaître de la requête déposée par la République de l'Inde le 8 mai 2017. 2. Par 15 voix contre 1, rejette les exceptions d'irrecevabilité de la requête de la République de l'Inde soulevée par la République islamique du Pakistan et dit que la requête est recevable. Pour M. Youssouf, président, Mme Choué, vice-présidente, M. Tomka, Abraham Benouna, Cansado Trindade, Mme Donoyou, M. Gaya, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge. Contre, M. Gilani, juge ad hoc. 3. Par 15 voix contre 1, dit que, en n'informant pas sans retard M. Kulbhushan Jadhav des droits qui sont les siens en vertu de l'alinéa B du paragraphe 1 de l'article 31 de la Convention de Vienne sur les relations consulaires, la République islamique du Pakistan a manqué aux obligations que lui impose cette disposition. Pour M. Youssouf, président, Mme Choué, vice-présidente, M. Tomka, Abraham Benouna, Cansado Trindade, Mme Donoyou, M. Gaya, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge. Contre, M. Gilani, juge ad hoc. 4. Par 15 voix contre 1, dit que, en ne notifiant pas sans retard au poste consulaire approprié de la République de l'Inde en République islamique du Pakistan la détention de M. Kulbhushan Jadhav et en privant ainsi la République de l'Inde du droit de rendre à l'intéressé l'assistance prévue par la Convention de Vienne, la République islamique du Pakistan a manqué aux obligations que lui impose l'alinéa B du paragraphe 1 de l'article 36 de la Convention de Vienne sur les relations consulaires. Pour M. Youssouf, président, Mme Choué, vice-présidente, M. Tomka, Abraham, Benouna, Cansado Trindade, Mme Donoyou, M. Gaya, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge. Contre, M. Gilani, juge ad hoc. 5. Par 15 voix contre 1, dit que la République islamique du Pakistan a privé la République de l'Inde du droit de communiquer avec M. Kulbhushan Jadhav, de se rendre auprès de lui alors qu'il était en détention et de pourvoir à sa représentation en justice et a, de ce fait, manqué aux obligations que lui imposent les alinéas A et C du paragraphe 1 de l'article 36 de la Convention de Vienne sur les relations consulaires. Pour M. Youssouf, président, Mme Choué, vice-présidente, M. Tomka, Abraham, Benouna, Cansado Trindade, Mme Donoyou, M. Gaya, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge. Contre, M. Gilani, juge ad hoc. 6. Par 15 voix contre une, dit que la République islamique du Pakistan est tenue d'informer sans autre retard M. Kulbhushan Jadhav de ses droits et de permettre aux fonctionnaires consulaires indiens d'entrer en communication avec lui, conformément à l'article 36 de la Convention de Vienne sur les relations consulaires. Pour M. Youssouf, président, Mme Choué, vice-présidente, M. Tomka, Abraham, Benouna, Cansado Trindade, Mme Donoyou, M. Gaïa, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge. Contre, M. Gilani, juge ad hoc. 7. Par 15 voix contre une, dit que, pour fournir la réparation appropriée en l'espèce, la République islamique du Pakistan est tenue d'assurer, par les moyens de son choix, un réexamen et une révision effectifs du verdict de culpabilité rendu et de la peine prononcée contre M. Kulbhushan Jadhav, de manière à ce que soit accordé tout le poids qui sied à l'effet de la violation des droits énoncés à l'article 36 de la Convention de Vienne sur les relations consulaires, en tenant compte des paragraphes 139, 145 et 146 du présent arrêt. Pour M. Youssouf, président, Mme Choué, vice-présidente, M. Tomka, Abraham, Benouna, Cansado Trindade, Mme Donoyou, M. Gaïa, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge. Contre, M. Gilani, juge ad hoc. 8. Par 15 voix contre une, dit que la poursuite de l'exécution constitue une condition indispensable au réexamen et à la révision effective du verdict de culpabilité rendu et de la peine prononcée contre M. Kulbhushan Jadhav. Pour M. Youssouf, président, Mme Choué, vice-présidente, M. Tomka, Abraham, Benouna, Cansado Trindade, Mme Donoyou, M. Gaïa, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge. Contre, M. Gilani, juge ad hoc.
Good evening. We welcome the judgment delivered just now by the International Court of Justice in The Hague in favor of India in the case relating to Sri Kulbhushan Jadhav. The court, by a vote of 15-1, has upheld India's claim that Pakistan is in egregious violation of the Vienna Convention on Consular Relations 1963 on several counts. We also appreciate the direction by the International Court of Justice that Pakistan should review and reconsider the conviction and sentence given to Sri Jadhav by the Pakistani military court. We note that the court has directed that Pakistan is under an obligation to inform Sri Jadhav without further delay of his rights and to provide Indian consular officers access to him in accordance with the Vienna Convention. We expect Pakistan to implement the directive immediately. This landmark judgment validates India's position on this matter fully. We will continue to work vigorously for Sri Kulbhushan Jadhav's early release and return to India. Thank you.